Good morning, everyone. Thank you for joining us for the Nuts and Bolts of Fair Housing Part 2. I'm Christy Baglow, the Director of Statewide Training for Florida Legal Services. If you happen to miss the fabulous presentation last week, Nuts and Bolts of Fair Housing Part 1, it has been recorded, so just email me and I'll be happy to get you the video and the materials. This webinar is being recorded and the video will be sent out afterwards, along with a link to all the presenters' materials in a shared drive. First, I would like to thank Community Legal Services in Mid-Florida, Bay Area Legal Services, and the Department of Housing and Urban Development for helping develop this webinar. We have 3 presenters today. First up is Jeff Hussey. Jeff Hussey is an attorney at Community Legal Services in Mid-Florida, where he runs the Fair Housing Program. He has been practicing law in Central Florida for the past 30 years. Next up, we will have Lizzie Johnson. Lizzie is the managing attorney of older adult programs at Community Legal Services in Mid-Florida. She has been practicing in public interest law for 17 years and is affectionately referred to as a generalist at CLSMF. And last but not least, we will hear from Marty Lawyer. He is an attorney at Bay Area Legal Services in Tampa. He has been an active member of the Florida Legal Services Housing Umbrella Group since its inception in 1982. Since 2013, Marty has specialized in representing claimants and plaintiffs in housing discrimination cases under the U.S. Fair Housing Act. So thank you to all of our presenters today. We will be taking a break after each presentation to give everyone time to stretch, and we will start with Jeff Hussey first. Welcome, Jeff.
Thank you, Christy. Good morning, everyone. My topic today is how is COVID-19 affecting fair housing? This is some new uncharted territory that we're in. We've never seen this before. There's no map, set of instructions, or case law to specifically guide us through the social and legal dynamics of this pandemic. So what do we do in these uncharted waters? I think we have to think, then advocate. COVID-19 is a novel coronavirus that has not been previously identified. The virus causing the disease is not the same as the coronaviruses that commonly circulate among humans and cause mild illness, like the common cold. A COVID-19 outbreak could last for a long time in your individual communities, or it could have a short lifespan. We just don't know yet. Depending on the severity of the outbreak, public officials have taken stay-at-home orders and shut down businesses that we're now trying to reopen. Unfortunately, the shutting down business has cost a lot of people their jobs, their source of income, and their ability to pay for their housing. But the ultimate goal is to reduce exposure to the COVID-19. People in the U.S. are worried or anxious about their friends and relatives who are living in or visiting near areas where COVID-19 is spreading. Some people are worried about getting the disease from these people. Fear and anxiety can lead to social stigma, for example, toward people who live in certain parts of the world, people who traveled internationally, and people who are in quarantine or healthcare professionals. In my opinion, stigma is a discrimination against an identifiable group of people or place or nation. Stigma is associated with a lack of knowledge about how COVID-19 spreads, the need to blame someone, fears about the disease and death. As advocates, I think we need to base our strategies going forward on the science, not on rumors or myths. As we all know, fair housing is there to help limit discriminatory practices in housing. The act was created on the principle that every American should have an equal opportunity to seek a place to live without being afraid of discrimination due to factors outside their control. This protection is vitally important, I think, in this environment we're currently living in. As advocates, we need to address the issues that could lead to discrimination in those protected under the Act. You can't help but turn on the news and you can get whatever opinion you want with regards to how COVID-19 is affecting communities, whether good or bad. The number one thing that we all think about in fair housing when we have some type of infectious disease is disability. And the core question is whether COVID-19 is a disability under the Fair Housing Act. From things that I've been reading and things that I've heard, there's a split of opinion within HUD as to whether or not this is actually should be considered a disability. The Act defines a person with disability, meaning those individuals with mental or physical impairments that substantially limit one or more major life activities. This could include such conditions as blindness, hearing impairment, mobility, HIV infection, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disabilities, etc. The term major life activity may include seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. How COVID-19 is going to affect each individual is different, and that's what makes this challenging. It could affect one person dramatically, and another person may have just minor side effects from suffering from the disease. Since the Fair Housing Act affords no protection to individuals without disabilities, we need to make sure as advocates that we can establish the condition COVID-19 and what the individuals are suffering from is in fact a limitation of major life activities. Housing providers would not have to protect individuals if they're a direct threat to the personal properties of their housing. Determining whether or not someone poses such a direct threat must be made on an individualized basis and cannot be based on general assumptions or speculations about the nature of the disability. And that's what kind of concerns me the most is there's a lot of misinformation out there about the COVID-19. And if people are going based on what they read on Twitter, Facebook, Instagram, then they may not be getting the correct information. So that's why I think science is our best bet here. For me, in researching this, since there is obviously no case law on this, we haven't had a pandemic like this since the Fair Housing Act has gone in effect, has affected so many people. I think the best way to attack this would be on the grounds that this is an infectious disease. And the reason I say that is because we do have a U.S. Supreme Court case that determined that HIV is a disability under the ADA. So I think that is good case law or precedent for us to utilize in trying to establish that COVID-19 is in fact a disability under the Fair Housing Act. The Bragdon case dealt with a woman who was suffering from HIV, and her disability that they were claiming in the lawsuit was that she could not procreate because she was fearful of having her baby infected with HIV. Since the ADA addresses substantial limitations on major life activities, not utter inabilities, when significant limitations result from that impairment, the definition is met even if the difficulties are not insurmountable. And I think that is comparable to the COVID symptoms. If you read the opinion, it's a lengthy opinion, but they cite the legal counsel, the Department of Justice, that saying that the ADA protects symptomatic and asymptomatic HIV-infected individuals against discrimination in any covered programs. So I think that takes care of both the positive and those who are at risk of suffering adverse consequences from COVID-19. They fortunately had the backing of the Surgeon General. At that time, it was Dr. Koop, saying that from a purely scientific perspective, persons with HIV are clearly impaired, even during the asymptomatic phase. The Office of Legal Counsel determined that asymptomatic HIV was a physical impairment under the Rehabilitation Act because it constituted a physiological disorder or condition affecting the hepatic and lymphatic systems. And they further determined that HIV imposed a substantial limit on the major life activity of reproduction. So I think that gives us good groundwork to argue that COVID-19, whether symptomatic or asymptomatic, can be classified as a disability under the Fair Housing Act. Now, obviously, this is pure argument at this stage because we don't have any courts interpreting this. We don't have HUD interpreting this as far as I know yet. But I think we can use the same analysis as HIV to COVID-19. The symptoms of COVID-19, people had a wide range of symptoms from mild to severe, and those include fever, cough, shortness of breath or difficulty breathing, chills, repeated shaking with chills, muscle pain, headache, sore throat, and I guess some people now are saying a loss of taste or smell. So can those be considered affecting major life activities? I think they can, because major life activity under the Act means functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, working, reading, and even interacting with others can be considered a major life activity. Obviously, if you're suffering from all these conditions, you're highly contagious, you cannot perform all of these activities. Your neighbors certainly don't want you knocking on the door, coming in and speaking with them if you're suffering from the disease. The ability to obtain shelter is one of the most basic human needs, and thus it is a major life activity. I think we can also argue, with the stay at home, with the inability to interact with others, I think that we can say that is, if you're quarantined to your house, that is obviously affecting a major life activity. You can't go out and do your grocery shopping. You can't function in your housing and do all the things that are necessary because you're suffering from the disease. So I think that can be a factor that directly affects major life activities. Some of the other areas that I think COVID-19 can bring it under the Fair Housing Act, one would be race. If you read some of the stories now and some of the scientific findings, that the coronavirus is affecting people of different races in different manners. Some of the states have released the information, and data from the CDC are saying that African Americans represent 1/3 of all deaths from COVID-19. And that's true even though they only represent 13% of the national population. This kind of brings up the argument of, can we argue if a housing provider is taking adverse stances against people with COVID-19, this is potentially a desperate impact rule type of case, because if you look at what the statistics show, that it is affecting people of the African American race disproportionately from all others. So therefore, if you are taking a policy against individuals with COVID-19, you could be affecting or discriminating against race. The other one that is of concern right now, I think, is national origin. You've seen stories out there where discrimination is being taken against Asian Americans and other people of Asian descent. It's clear that has spiked in the wake of the coronavirus pandemic. Since it is illegal to deny housing or shelter because someone is from one of the countries most affected by COVID-19, I think that if an individual is denied housing or discriminated in their housing because they are Asian or Asian American, then that is a violation of the Fair Housing Act based on the COVID-19. It's illegal to have different rules for individuals based on their national origins. So if a housing provider is taking the stance that we don't want Asian Americans in our housing because they're from a country where there was a high incident or where allegedly the virus started, then that obviously would be a violation of the Fair Housing Act. Another one that is concerning that doesn't apply across the board is age. Some jurisdictions do add an additional protected class of age, and there could be discrimination based on age. People who are 65 or older are more likely to have serious COVID-19 illness. This may be because they have weakened immune systems, that they're in closer proximity to other individuals who may have suffered from COVID-19, or they're not getting the necessary medical treatment that's necessary. But this is something that can be considered potential, if your jurisdiction protects age, as another potential way to bring individuals suffering from COVID-19 discrimination under the Act. One area that is of greatest concern, I think, is potential discrimination based on sex. I was in a conference call the other day and heard that one jurisdiction has seen over 300% increase in sexual harassment claims made in housing. And obviously, that's a concern not only with HUD but all of us. And I think that goes back to what we talked about earlier, and the fact that people are losing their jobs. They can't afford to pay the rent. I think I read one statistic where in April, a third of the country was not able to pay their rent and did not pay the rent. So if individuals aren't paying their rent, then the unscrupulous landlords may find other ways to get rent paid. And one of those could be asking for sexual favors in lieu of rent. There are basically two types of sexual harassment that are recognized by the courts under the Fair Housing Act. One will be the quid pro quo, and that's when a housing provider requires a person to submit to unwelcome requests to engage in sexual conduct as a condition of obtaining or maintaining housing or housing-related services. What I've been hearing is where that's coming up is obviously a housing provider is demanding sexual favors in lieu of rent payments. Obviously, I think that that's going to be more of the smaller people who have only maybe 5 or 6 units, but you can't rule out the fact that there are property managers out there, landlords who will take this opportunity to try and get sexual favors in lieu of paying rent. The other would be the hostile environment under sexual harassment, and that occurs when a housing provider subjects a person to severe, persuasive, unwelcome sexual conduct that interferes with the sale, rental availability, or terms, conditions, or privileges of housing-related services. A housing provider takes certain liberties because the tenant is behind on their rent or cannot make their rent payment. The Department of Justice obviously wants to hear if you have any clients, any people who have contacted you and have been complaining of sexual harassment. That was the theme of this year's Fair Housing Month, which was obviously disrupted tremendously because of the COVID-19. But if you have a client who comes to you and was sexually harassed, you should contact your local Department of Justice, report it to them. You can fill out your civil rights claim form with them. They'll start their underlying investigation as well. And the one advantage of that is they can possibly root out if this is a systemic type of situation going on in a project. We can't go out and knock on doors to ask if people have been harassed, but the DOJ can. And there's a good likelihood that if they're harassing one tenant, they're probably harassing more. So I would strongly encourage you to work in conjunction with the DOJ in investigating any potential sexual harassment in housing. So what can we do for our clients who are suffering from COVID-19 or have symptoms related to it? Obviously, the most common thing is going to be to ask for reasonable accommodations. The biggest one is going to be rent. We have so many people who have lost their jobs, they can't pay their rent, and just abatement of rent is not something that is recognizable under the Fair Housing Act. But you can ask for certain accommodations with regards to rent under the Act. It doesn't excuse the payment of rent, but you can ask for an accommodation that, due to the disability, there could be, for instance, a waiver of the late charges. Negotiate as a reasonable accommodation payment of back rent in installments. I think that is going to be one of the most important ones to try and save housing for so many people, because if they hadn't paid rent in 2 to 3 months, when the stays are lifted, the moratoriums are lifted throughout the country, people are not going to be able to pay 2 or 3 months of back rent in one lump sum. So there's going to be need for recoupment of the back rent in installments. If they have a disability, if they've been suffering from or tested positive from COVID-19, use that disability as a way to perhaps negotiate a a reasonable payment plan to pay the back rent. Now, obviously, this is going to become a bigger issue if you don't go back to work and you don't have a steady income. Another issue that's come up here locally with me is individuals, especially college students, who are in apartments that have activity fees. Obviously, you can't do activity fees if you can't get out and do the activities. So they're asking for waivers of that. And if you're suffering from COVID-19, then you obviously have a disability. You should not be interacting with individuals. So it is very reasonable to ask for a waiver of any activity fees that you might be assessed on a monthly basis from the housing providers. I think it should be clear when you're asking for a type of reasonable accommodation with regards to rent that you're not asking for a waiver of the rent due to disability, because I don't think that would be considered reasonable under the Act. Another area where we can ask for reasonable accommodation for someone who is positive or maybe even quarantined due to the COVID-19 would be some leases require the tenants to do certain maintenance and upkeep the properties. They have to cut the grass. They have to make sure the hedges are clear. If due to the virus, your client can't perform those upkeeps or maintenance, then it would certainly be appropriate to ask for reasonable accommodation to be waived or postponed, or asking the provider or the landlord to provide someone to do those upkeeps on your behalf. You certainly, if you're suffering from this, are not going to be able to go out there and do any type of physical or manual labor, even if it is required under your lease. I think one of the gray areas is going to be, how do we protect those with a compromised immune system? As I said earlier, seniors are vulnerable because they have the compromised immune system, and there's warnings out there for people who have lung issues, who have breathing issues, that they are more susceptible to complications or risk associated with COVID-19. So can we use that as a protection under the Fair Housing Act? I would say that if the tenant has a compromised immune system or is in a high risk category, they need to request a change of policy or rule that potentially could expose them to individuals who had COVID-19. I don't think there's anything unreasonable about that. If it could be such as inspections, a lot of, especially public housing, they have monthly inspections of their units, but you can ask for reasonable accommodation to delay any unit inspection so as not to expose that tenant who has a compromised immune system to potential exposure. Another is going to be caregivers. A lot of leases have prohibitions against any additional individuals in the housing. If there's a need for a caregiver because a person has or is suffering from COVID-19, a reasonable accommodation request needs to be made for an exception to the rule of no additional individuals in the unit. So you have to get that caregiver in there. Seniors, I've actually had this one come up in my practice. A lot of package delivery goes to front desk. Many of the housing providers, especially in the 202 properties, have, in essence, shut down the local staff. Just have a skeleton staff. There's no one at the front desk. They're working from home. So how are the packages getting delivered? Some are actually prohibiting deliveries from outside sources because they don't want that risk. Well, a lot of seniors are getting their medicines delivered to them via mail. So there needs to be some type of reasonable accommodation to allow those packages to get to the facilities so that the tenants can get their medication or needed supplies. Another issue, and this has come up too, is some places went to exclusive online rent payment. Some people can't do that because they have the disability. In the same token, some places require live rent payment. If you are suffering from COVID-19, you don't want to expose yourself to the general population, then a reasonable accommodation as to mailing the check or putting an envelope and taping to the door, some type of accommodation rather than going to the office and putting it in the drop box. Another issue that has come up, some places have strict regulations as to what form of payment they'll take. I know many of my clients rely on getting money orders to pay their rent. Well, if they can't leave their house, and that's because the landlord only will take a money order or a cashier's check. Well, if you can't leave the house, you can't get that money order, you can't get that cashier's check from the bank. So you're going to need to ask for a reasonable accommodation to allow a personal check or cash or credit card if necessary in order to pay your monthly rent. I would hope that landlords, given the situation we're living in, would be accommodating, especially if it means they're going to get paid. I would assume and hope that landlords would rather get a check or cash rather than an eviction notice to someone for non-payment. Another concern I have is how we're going to show the disability if the person is not tested positive for COVID-19. How do we establish a disability and the need for the accommodation? If you don't have that positive test result to show the housing provider, or maybe you haven't tested positive or had the antibody, how are we going to prove the disability if there's no ability to get to a healthcare provider to get that note? That's when we got to really think outside the box. One way to establish a disability, if client is on Social Security disability, on workers' compensation, on long-term disability from a source, that's at least establishing a baseline that a person has a disability. If you can't get that, then you're going to need to start looking for alternative documentation, peer groups, non-medical servicing agency, a reliable third party. They just have to know about the disability and can provide verification of the disability. If a person has nurses that come in, they have caregivers that come in, they're part of a Zoom support group, things like that. We just really have to think outside the box because a lot of healthcare providers are extremely busy and they aren't going to have time to write the necessary accommodation note. You can provide your clients with the necessary information that most housing providers are going to require to establish a disability, and they can then seek out the opinion from the PA perhaps at a healthcare facility, a nurse at the healthcare facility, some way to document that disability to get the accommodation that's needed. And I'm going to touch that on again on what we anticipate seeing as potential defenses to people seeking reasonable accommodations under the Act. First and foremost, I think it's going to be safety. Landlords are going to take the position that I don't want individuals with COVID-19 in my housing because they are causing a public safety concern, not only for my residents, but for my workers and everyone else in the building. Although it is legitimate that safety is something that landlords are allowed to undertake, the courts generally have cautioned that housing restrictions based on considerations of health or safety must be narrowly tailored in order to pass muster under the Fair Housing Statute. So a broad policy of individuals who have tested positive for COVID-19 are not allowed to live here, I think would be considered discriminatory. And even if they try and say that we're doing that for the safety of all of our other residents, I think that can be challenged in court as discriminatory. The other one that I just kind of touched on is the medical documentation. Landlords are very sticklers a lot of times to get the appropriate medical documentation. And this is where we have to be careful once again as advocates to make sure that what the requirements that they're doing don't go too far. Landlords, property managers, they want medical records, they want stuff that clearly they are not allowed to have or they're not entitled to. I think that if a person is tested positive for COVID, if they had that positive test result, that's as far as the inquiry should go. If a person has a compromised immune system and that's what they're seeking the accommodation for, then that's something that's not an obvious disability, and that's something that you're going to need some further documentation on, and that's where, I think a compromised immune system could be. A non-medical professional could say they've known a person for X number of years. They know that they've suffered from COPD or some other type of lung issue. The other argument that I've seen people toss about to COVID-19 is to argue that the infection is only a short-term condition that should not be regarded as substantially impairing a major life activities. However, I think that is an easily rebuttable presumption, because the fact that a disability is temporary does not exclude the disability from coverage under the Fair Housing Act, so long as at the time that you were requesting the accommodation, it was severe enough to substantially limit that major life activity you're claiming. I went through and did a case law search to see if anything has come out there. The only thing I found directly dealing with COVID-19 was just a slip opinion out of Texas, and that was a pro se plaintiff who had a fair housing retaliatory eviction claim, excuse me, and that was an issue dealing with the state case on eviction was finalized, and I'm not sure what the landlord-tenant laws are in Texas, but here in Florida, a writ of possession is issued, and you have 24 hours to leave. In this particular case, the plaintiff was told that they had to get all their property removed by a certain time. They sought a temporary restraining order because they had been self-quarantined in another city due to possible exposure to the virus, and that they were unable to retrieve their property. The court in that case denied the temporary restraining order, and did not feel that it came under the Fair Housing Act. It's not a detailed opinion, and since it's a pro se plaintiff, it's not something that I would want to put much reliance on at this point in time. The only other case I found was out in California, where the plaintiff was alleging or trying to get reasonable accommodations in their student housing, and one of them was due to the accessible transportation. The complaint asserted disability discriminations against the college and other defendants. However, after COVID hit and the student transportation was actually stopped because the education was moved online, they were still seeking a temporary restraining order, and the court felt that the issue was moot because all student transportation services had stopped, so it didn't go any further into the the case. So that is just a brief, quick summary of what I think are going to be the issues with COVID-19. Let's hope that we don't have to test this. I do think that, I think we all are in agreement that we're going to have probably a tsunami of housing issues related to evictions and other matters. I think as advocates, we need to explore whether or not we can use arguments under the Fair Housing Act to prevent evictions or to save people's housing. I think it's of vital importance to all of us. And if you have any questions, you can put them in the chat box. If you need those cites to the Supreme Court case, I'll be happy to give that. If you need the cites to those two slip opinions, I'll be happy to give you the names of those as well. And I thank you for your time and attention this morning.
Thank you for all that great information, Jeff. We did have a couple questions come in. You already answered some of them in the last few slides. But the first question we have is, does the reasonable accommodation request for a waiver of late fees and/or repayment installment plan have to be directly related to the client having COVID-19?
It has to be related to the disability. And the theory and the thought process is that a person has suffered from the disease, and because of that, they've had been quarantined, they've lost their source of income. So you have to say that I'm disabled since I am positive, and that is why I have not been able to make rent payments. So it has to be, you have to tie it back to disability, because you can't just do a blank. I mean, you can obviously try and do that. You can advocate for your client who maybe didn't suffer from COVID-19, but if you want to make it a reasonable accommodation, there has to be some form of disability that is affecting a major life activity.
Okay, next question is, if the lease has expired, can the tenant request a reasonable accommodation due to COVID-19?
I think that's a good analogy, especially now that, you know, we don't know the extent that it is still floating in the air out there. But once again, you have to go back to the disability, and that would be a excellent one to argue if you had the compromised immune system. It would not be because of my disability, because of the compromised immune system, it would not be feasible or in my best interest to be out there looking for alternative housing during this pandemic, because it's going to unnecessarily expose me to potential infection. So therefore, I'm asking for reasonable accommodation of, you know, it may be one that you would have to renew monthly, because we don't have a script on how long this pandemic is going to last and how long the quarantines are going to last or the stay-at-homes are going to last. So once again, just like the rent payment, the non-renewal, you have to tie it to a disability.
Okay, great. We have one.
Okay.
Go ahead.
No, I was just gonna say, and right now, most jurisdictions, I know here in Florida, they're moratoriums on service of writ of possession. So there's not a mechanism for landlords or property owners to get into court right now to get people out. But those are all going to expire at some point in time, and that's when our role as advocates are really we're gonna have to step up to the plate and really help these people.
All right, we have one last question. What can be used as documentation for a reasonable accommodation, given that patients are generally only given discharge papers or nothing at all? I'm assuming the questioner means when they go to the hospital.
Right, and that is going to be a big problem. Well, one, I think if in that particular instance, let's say you do have you were hospitalized and you do have at least something to show that you were in the hospital, that's the starting point. You know, even if it's the wristband they put on you when you're in the hospital to show you were a patient, but then you're going to have to find some type of documentation from, you know, it could be, you know, your caregiver, your significant other that, you know, that can vouch for that, you know, Mary Sue was in the hospital for the last week suffering from COVID-19. At least that's the starting point. That at least gets the process rolling, because most housing providers are going to just close the door on you if you have nothing. If you just send a letter saying, I want a reasonable accommodation because of X. So you're at least getting the ball rolling. You're going to have to then follow up with you know, some type of provider, whether it be your primary care physician, your nurse at your doctor's office. And I know a lot of people don't have a primary care, don't have health care, so they can't afford, you know, ongoing medical care. That's when you're going to have to find somebody that is familiar enough with you and your condition that can write a letter or give them some type of statement to substantiate that your condition is affecting a major life activity.
Okay, thank you so much for all that information, Jeff. We're going to go ahead and switch over to Lizzie Johnson now. And if you have additional questions, we'll probably have time for them at the end of this presentation. Lizzie, I think you're still muted on your end. I'm trying to unmute you on my end. Okay, great. Welcome, Lizzie.
Okay, great. Welcome, everybody. Thank you very much for having me today. I'm briefly going to talk about the impacts of COVID-19 on older Americans in housing. As we all know, the coronavirus has presented a new wave of difficulty for millions of Americans, including the vulnerable population, which includes seniors and individuals with disabilities. Next slide. Currently, Florida has over 20 million Floridians in Florida, and it's estimated that 26.5% of Floridians are older Americans. By 2024, Florida expects there to be over 8 million seniors residing in Florida. Next slide. It is widely reported that the severity of the coronavirus increases those who have pre-existing illnesses and older Americans. The CDC reports that the United States has 25.6% of all its population to be disabled, and 28.1% of Floridians are actually disabled. Many older Americans and individuals with disabilities survive on a fixed income. The coronavirus probably is going to put a financial strain on this vulnerable set of population like it has done for everyone else. I have some statistics up here for you. Currently, a large percentage of older Americans are actually living at or near the poverty level. About 54.6% of older Americans in Florida are actually females. About 27.7% are minorities residing in Florida. 8% of Floridians, older American Floridians, are limited English proficient. The ARDC in Broward, which is the Area on Aging agency in Broward County, they estimate that 50% of all new home construction in Florida is really purchased by older Americans. The spending power of Florida elders or older Americans is $135 billion annually, almost $15 billion more than people age 49 and under. Next slide. Reviewing the statistics about older Americans, it was shocking to me to find out that numerous older Americans have not just one, but more than one disability. Many older Americans, they live at home, they live by themselves or with other relatives. Many older Americans are actually grandparents. In 2016, the AARP estimated that over 161,000 Floridians are actually grandparents caring for their grandchildren. Yet the Department of Elder Affairs in 2018 found that over 294,000 grandparents are raising their grandchildren. Next slide. Next. We went over that one. Okay. On this slide, it goes over the statistics concerning veterans. There's about 800,000 veterans that are actually older Americans. So being a veteran and being an older American is also something significant, and that should also be something that's on everybody's minds. Because as I am in my day-to-day, I'm often shocked when I encounter an older American and I find out that they're either a veteran or they're a spouse of a veteran. And not only are they older American, but they qualify for veterans benefits, but they never signed up. Often, or even if they did apply, they never appealed. So that's something that should always be on our forefront, is that when we see older Americans, just take a few seconds to find out if maybe we can help increase their income, because a lot of times they qualify for VA and they just never pursued it. It may just be the culture of being a veteran, which is sometimes if they're told no, they don't question it, or they just never pursue it just because that's just how it goes in the VA world. Many older Americans are actually living at home with a mortgage, and some of them are actually renting. So fair housing applies both as a renter, and in some circumstances, it also can apply to homeowners. Next slide. Next. All right, so here's the fun part. There's a lot of issues that may present itself as stemming from COVID. We already heard from Andrea, and we heard from Jeff, and we heard from Catherine earlier, that a lot of seniors or people in general, they're going to be facing some housing issues. We know more than likely one of the first things we're probably going to see is a lot of evictions. The evictions may present themselves from non-payment. It may present from a notice of non-renewal of tenancy. It may present itself in a 7-day violation because they may have an unauthorized guest or some other rule violation. So it's going to be on us to figure out exactly, dig a little deeper to find out, why exactly are you receiving this notice? Why can't you pay your rent? Is your rent issue based on, as Jeff said, it's because you couldn't get to the lockbox? I've had that with clients who were not seniors over the years in the past, and that usually was around the hurricane time. If you dig a little deeper, well, why did you get the notice of non-renewal? Well, you may find out that the client may have had many different violations, and this is just the one way the landlord wants to get them out. But is it based on discrimination or some other protected class? Another issue you're going to see maybe is the notice of default. Did they get a notice of default before COVID? And now that COVID is over, they have never addressed it with their lender. So now their lender wants to pursue foreclosing them from their home. Is the foreclosure from the lender? Is it an HOA related issue or a condo issue? Because those foreclosures, they really work differently. Whether it's residential, a condo, or HOA, they can move very quickly, or it can move slower, or you may have more wiggle room to try to see if you can protect that senior and preserve their housing. Another issue is, the reality is, a lot of companies and a lot of businesses are not going to survive COVID. That's just the sad reality. And so the landlord may file bankruptcy. You may see more of that. And so how do you protect not just older Americans, how do you protect tenants in general when their landlord is filing bankruptcy? Are they trying to do a liquidation? Are they trying to get permission from the bankruptcy court to protect themselves from the debtor so they can try to sell it? Those are issues that we're going to have to, we may be facing soon, is the bankruptcy and also the landlord selling the complex. It's no surprise that when landlord sells the complex, they sell it to people who seem not to understand that, hey, you take this property subject to any leases that's already outstanding. But what happens when you have tenants who are still living in the complex and they're month to month? Are the landlords going to try to keep them? The new landlords, are they going to try to keep them, or are they going to give them a notice of non-renewal based on the month-to-month tenancy? And whether those tenants are going to face any kind of holdover issues if they refuse to leave. Another issue you're going to see maybe is more minor grandchildren moving in with older Americans. Why? Their parents may be unemployed. Their parents may be sick. Their parents may have passed away. And so grandma, grandpa are the only ones that's left, or aunt or uncle. So they need somewhere safe, and so they take them in. Well, question on my mind, and I'm not a fair housing expert, is what happens if that older American is living in, say, a 202 building or a 55 and up community? Does that minor child, still gets to live with that loved one, and that's the only person they have? Will the complex or facility make a reasonable accommodation to allow that minor to live with them? And can they? Another issue you may have is the probate. The tenant dies. What happens? Okay. A big issue I see, of course, everyone has already talked about it, is caregiver. And why is the caregiver needed is really my question. Is the caregiver needed because of the disability, or is the caregiver needed because of some other reason? Diminished capacity. So that's always a touchy subject. Did the tenant have diminished capacity when you met with them? That means, did you notice during the initial consultation that they had the diminished capacity and you took their case anyway? Or did the diminished capacity occur during the course of representation? I believe, based on my review of like the ethical rules and some of the opinions, is that the bar takes a different look at both of them. I have attached in the materials some couple of articles and some information relating to diminished capacity that may be very helpful during the course of representation. Next slide. Some other housing issues that may occur is unlawful detainer or ejectment actions. What happens if, like I have a call this week, you have an older American who hired someone to be a temporary caregiver during COVID. Well, they want them out the house now. So how do they go about that? Is the court going to allow that? I know they have a moratorium on evictions and foreclosures, but what about unlawful detainers and ejectments? How do you get unwanted caregivers out? Also, someone may be trying to eject an older American from where they are. I also anticipate we may see some during representation. You're probably going to see all kind of real estate issues, and that include the typical title defects. If someone dies, you're probably going to see probate issues, but also ancillary probate issues that people don't think about is that they may benefit, sadly, from someone passing away by reminding them that they may qualify for a widow's exemption. A lot of people don't know that the state has widows exemptions. They have a disability exemption. They have a blind exemption. They have a veterans exemption. They have a senior exemption. They have a first responder exemption. And a lot of older Americans don't know that they may qualify for these extra exemptions for their property taxes that can reduce their bill. Unfortunately, they had to have applied for that early in the year. So even if they apply for it now, it won't impact them until next year. And that is another concern for me, because I know several seniors or older Americans who have not paid their property taxes. And even though we have a temporary forbearance on those property taxes, they're going to come due soon, because all of those temporary stays pretty much are going to go away probably in the next 30 days or so. So hopefully people have been using this time wisely, and they may not, because of the stress of the pandemic, to think about ways to handle some of these financial issues that they're going to be hit with. Another issue I anticipate is probably the stable one that has always been around, is the predatory lending, which is probably going to come back. A lot of people who live on fixed income, they don't always have the best FICO or best credit score. So you always have those secondary lenders or those investors who are always out there willing and waiting to charge predatory interest rates to vulnerable populations. So those issues probably are going to resume and resurface very soon. Next slide. The NCLC has a free training, a 3-series webinar that starts this week and is going to go for the next 3 weeks, which is basically going to address helping homeowners in the COVID crisis. So I encourage you all to attend that, because usually have some great ideas and tools to help us advocate on behalf of our clients. Next slide. Some additional areas of law that impacts older Americans, of course, is elder abuse. Just because we're in COVID doesn't mean that abuse stops. There's been reports that DV and child abuse still occurs, even though the reportings are down. Probably because the places, the mandatory reporters such as schools or the Meals on Wheels sites or the social workers or the CNAs who visit these places, they're closed or they're limiting their contact. So I expect that to still be an issue and around. Rental assistance. If you encounter any clients who need assistance paying their rent, they really should contact either a HUD housing counselor. A lot of HUD housing counselors, even though it's supposed to be for pre-foreclosure counseling, a lot of them will still have access to resources for people who are also renting. And basically it's like rental counseling, reminding people that, hey, you can go to your county human services or your county senior services department. Depending on which county they're in, they maybe have different names. I provided a list of resources I believe that may be helpful, even though it's geared towards older Americans. It can certainly be used for anyone. There's Salvation Army and a lot of other great nonprofits in many of our communities that are willing to step in and help. Of course, there's so many people who need the rental assistance, so pretty much it's first come, first serve. Another issue that may come up is access to premises. Access to premises can come into play when you have someone who is sick or deceased. Who has the right to come in and get their personal belongings? I provided you a sample one-sheet form that I prepared for my seniors in the 202 building because the landlord, they have multiple locations, several years ago said, hey, you guys, I need a copy of your will. Well, first off, I don't believe that's true. So I created a simple little form called Access to Premises. I now give it to all my clients, especially if they're older, if they're renting and I know about it, to encourage them to say, hey, anytime you go to a facility, whether it's a rehab or a nursing home or an apartment complex, just fill out this form, give a copy to them, just to let them know in any event you become incapacitated or if you pass away, these are the people who have the right to come in to retrieve your personal belongings. I have had a facility manager call me up, not their lawyer, but call me and ask me which one of the fighting children should they give the property to. I told them that they should call their lawyer. I already knew which one was not supposed to get it, and that's the one who was there causing the big fight. So I encourage clients to always fill out that one form so that everyone knows. Another issue, ancillary issue, is public benefits and VA. Clients should be encouraged to always apply for these benefits because that really does help them with their rent. And being on a fixed income, the more income they have, the more likelihood they can live in stable housing, and they can live where they are, and they can age in place. And aging in place is very significant and very important for older Americans. Another issue I anticipate is going to be consumer, a rise in debt collectors. Some of them may be time barred because whenever there's money around, they always pop back up. There's probably going to be an increase in garnishment. Over 17 years of doing this, pretty much I always see a huge filing of garnishments during tax season and stimulus time. Because why? That's free money that they're going to try to go after. And pretty much unless the garnishee is on their toes and they know to call legal aid, they may not know that they may have a chance to fight that and to keep those funds. And I added children's rights in case you have clients who have minors with disabilities or minors, period, who are residing with them, and they may have school issues. Next. Okay. Diminished capacity is more prevalent as one ages. According to the 2010 U.S. Census, there are more than 40 million people that are over the age of 65. It is projected by 2025 this age group will comprise of 20% of the U.S. total population. In 2011, there was some type of disability by 65% of men and 38% of women in that age group. Next. The Florida Bar in 1973 has said that a lawyer having a good reason to doubt a client's competency owes his client a duty to express such doubt to him and request permission to obtain a judicial determination of competency issue. Then, if the client refuses to consent to a competency determination, the lawyer should move for leave to withdraw from cause, but should continue to protect his client's rights until withdrawal is permitted. Next. Basically, we have an ethical duty to protect our clients, even if we're trying to protect our clients from themselves. There's ample case law that says there's a difference between bad decisions and incapacity. If you are in doubt of the client's incapacity, you are allowed to ask the client to get a medical determination. You can ask them to go to their doctor and have the doctor just write up an assessment whether the doctor feels that the client has capacity or not. You'll be surprised. Sometimes they are, and sometimes they are not. You can ask the client to execute a HIPAA release and get a copy of their medical records for your purposes, just so that you can determine whether you believe that your client has incapacity or not. If capacity is at issue, I urge you, before you settle the case at all or go to trial, that you address that issue. Because if you don't address that issue and your client didn't have capacity and you go ahead and you settle that case on their behalf, have you really protected your clients and their best interests? And really, have you really preserved all of the legal rights for your clients that they may be entitled to? In your materials, I have included some information on incapacity, diminished capacity, including the Ballot versus Wood case, which is a 50 case, which is still great law, about the process and the ethical duties and the judge's duties when capacity is at issue in the case. It can be reversible error if the judge is on notice that there is a capacity issue and the judge goes ahead and issue a judgment. It can be a reversible error. Okay, next. For the issue of time, I'm going to skip ahead to guardianship. So keep going, please. Stop. Right here is basically, I just want to put a plug in for a declaration of pre-need guardian. If you have a client who may be competent, but maybe on the getting ready to go on a decline, is that you may want to go ahead and do a declaration of pre-need guardian. That's where the client basically is just a statement, a written statement, a legal document that says, in the event that I get incapacitated or I'm determined to be incapacitated by law, I am going to nominate this person to be my legal guardian. I always recommend a client, if they can, have a primary and a backup person, and I provided the statute for you, and that is something that I believe that all clients should have. Next. I'm gonna skip ahead. Keep going. Third party involvement. Go back one. Third party involvement. This is something that's always going to be an issue. Is one, if a third party is present, generally there's no confidentiality and there's no attorney-client privilege. However, do you need this third party in order to represent your client? If so, you should limit your disclosures. There's ethical opinions on it, and there's comments in the rules about when you can use a third party and when you can't. If you need that third party to aid you in representing your client, you certainly can use that third party. Next slide. There's an issue that I like to come up with. The person likes to tell me is that they're a POA agent. And I'm like, really? Are you really a POA agent? Let me see the power of attorney. Oh, I don't really have one. Then you're not a POA agent. You're not a power of attorney agent unless there's actually a legal power of attorney. look at the power of attorney. Just because someone says it is, they have one, doesn't mean that's legal. I look at them all the time, and I can tell you that majority of the time, if it's not done by a lawyer, it's usually not done correctly. I have had them not signed. I have had them handwritten. I have had a durable power of attorney that was 1.5 pages. Yes, 1.5 pages, and they put the title durable power of attorney, and it had really no language on it because the first page was just one paragraph and the second page was just a signature with the notary. No, that's not a durable power of attorney and didn't cover anything. Another thing I always like to look at is exactly what does it cover. Just because it says durable doesn't mean it's really durable. Does it have the magic words that's required by statute? Does it cover why they're coming to your office, such as litigation? Is that specifically outlined in there? Is it outlined in there that the person has a duty or authorization to handle their real estate or their leases or their mortgages? If it doesn't have all that, more than likely it's not legal or effective. Was it witnessed by 2 people? Was it notarized? You'll be surprised. Okay, next. Next. And just a few reminders is that even if the person presents a power of attorney, it may have been revoked. The agent may have disavowed at one time. That means the agent has said that, oh, I'm just going ahead, legally no longer be responsible for it. Power of attorney ends at death. It also ends if the judge suspends those duties. Okay, so those are things to also remember. I am out of time. If there's any questions, please put them in the box.
Thank you so much, Lizzie. For those of you who don't know her personally, Lizzie is an expert in how to best serve older Americans. So I really appreciate all that information. Let me see what questions have come in. And while I'm looking at questions, Jeff Hussey had some information come in that he would like to share with you. Go ahead, Jeff.
Yeah, just real quick, it's kind of, the timing is uncanny, but I just got a letter from the U.S. Attorney's Office that I just wanted to read to everybody because it's dealing with the sexual harassment that I briefly touched on. In these unprecedented times, and as the nation mounts a response to the COVID-19 pandemic, we see the need to reconfirm our commitment to eradicating sexual harassment in housing in our district. Sexual harassment by landlords, property managers, maintenance workers, and others may violate the Federal Fair Housing Act. The Department of Justice, through the United States Attorney's Office, remains unwavering in the enforcement of this vital statute. As a result of the COVID-19 public health crisis, many in our communities have found themselves out of work, furloughed, or otherwise in dire financial straits. This has led many to seek abatements or suspensions of their rent or seek other accommodations during this time. While many landlords and housing providers have positively responded with understanding, sadly, others have seen an opportunity to exploit the financially vulnerable through demands for sexual favors and other acts of unwelcome sexual misconduct. This appalling behavior is illegal and will not be tolerated. Please know that the U.S. Attorney's Office stands ready to investigate complaints of sexual harassment in housings and to deploy all available enforcement tools against anyone who engages in this behavior. As a community leader, you can, let me scroll down, serve as our eyes and ears for these practices. We ask that you please contact us should you have any questions or receive any complaints of sexual harassment in housing. Remember, sexual harassment is illegal and fair housing is a right. Individuals should not be forced to submit to sexual harassment in order to stay safe within their homes during this global pandemic. I just wanted to share that real quick. That just actually came to my email while I was speaking, and just to show you that U.S. Attorney's Office is still actively wanting to pursue any complaints of sexual harassment. Thank you.
Thank you. That was perfect timing. So we had several questions come in. One of them was actually from the end of your presentation, Jeff. The question was, what if I finally get a test for COVID-19 and am not immune? Can this still be a disability to not go out or get out of the apartment? How do you think that will play out?
I think that's once again where we have to rely on if they have any other underlying disability, such as the compromised immune system, because it's all about having a disability that affects a major life activity. So, you know, if the landlord would probably say, if you came back negative for COVID-19 and you're still trying to get some type of accommodation, they're probably going to say that you don't have a disability and therefore I'm not responsible for this accommodation. So that's where, as advocates, we have to be creative to try and fit whatever that accommodation need is into maybe a pre-existing disability that is aggravated or enhanced because of the global pandemic.
All right, thanks. And the next question is for Lizzie. If a senior tenant who is suffering from COVID-19 and is at home has need of repairs in the apartment, what options does that senior have to get those repairs done if the landlord is aware the senior is suffering from COVID-19?
So the senior needs repairs in their apartment. They have COVID, and they want the repairs done. Correct?
Yes.
Okay, so that may be an issue, and it's almost sort of like when my mom's AC went out, and during COVID, and she had to call around to get people who are willing to come into COVID. I don't think that you can force outside repair companies or contractors to come into that apartment. I think the landlord has to make a reasonable, good faith effort to try to get repair people to come in and make the repairs. But I don't think that under the circumstances, I mean, I could see the landlord and say, hey, this is unforeseeable. We tried our best. We made a good faith effort. We could not find a repair person who's willing to come in and who can make those repairs. But on the flip side, the landlord cannot make this just blanket say no and make no effort to try to get a repair person in. Because I can see some landlords just saying, hey, oh, it's COVID, I just wait to the end. No, you have to try. Because there still is a lot of repair people who are, they don't care. They're, it's money is money. They just put on their mask and they just go on in. But what do the experts say? Yeah, and Marty.
Am I muted?
You're unmuted now.
I would say that if a repair is needed and it's one that's contemplated by the lease, and the repair won't be made, then they can, in landlord-tenant area, at least in Florida, do a rent withhold, do a proper rent withhold. If it's a specialized repair, I'd still say do a rent withhold and let the landlord argue, hey, I couldn't get anyone to come in during COVID. Because like you said, they'll just say it. You know what I mean? No one's going to come, but they didn't try. Or a lot of times, a lot of these small places, the landlord is the repair guy. So really, you just need to, if you've made the request for the repair and the repair hasn't been made and it's something that the landlord is obligated to do, then do a rent withhold. And do a proper rent withhold and follow those steps. But that's really more for a landlord tenant seminar, but you can look up the proper steps in your jurisdiction to do a proper rent withhold and then follow through with the client on that. I never send a client to do a rent withhold and then just say, okay, bye. I like to sit with them, stay with them, keep their file open, because typically that results in an eviction. As soon as you start withholding rent, they're going to evict you. Now, yes, it's a moratorium now, but it's only for non-payment of rent. So they can say, they could turn around on you and say you're not maintaining the property or you're destroying the property and we want to evict you. So always be careful of that and don't just leave them out in the wind. But I think the proper avenue there is a rent withhold. And you can also, if they are disabled, throw in a reasonable accommodation request. I love to send landlords more than one thing. They usually do not respond to a reasonable accommodation request correctly. And honestly, they usually don't respond to a rent withhold correctly. So you are doing two things that will protect your client's rights when the moratorium is listed and protect their rights under the federal law.
But on top of that, with Andrea, I would say, especially if your client is not reliable, I would recommend that you have your client deposit their rent money into your trust account. Because what's going to happen is the rent is going to be due. They're going to be evicted for non-payment because they went out and spent that whole rent check.
All right, next question. Do you see discrimination in nursing homes where people are being told they can't move in because they have COVID? Anyone seen that?
It's a different problem.
I have not. I've seen where you can't go to the nursing home because the nursing home is on lockdown. And so people who need to actually go into a nursing home can't get into a nursing home because of the COVID-19 lockdown, not necessarily because they have COVID-19. So that's unusual, but I know that they are the hot spots for COVID-19 also, where when there's outbreaks, they occur in the nursing homes. So I think I would have to sit with that for a little bit because I've never seen that happen. Have you actually seen that, or is it just kind of like a speculation question?
Maybe a speculation, but in the interest of time, we can follow up on that if anyone has any thoughts they come up with on that. And Michael Bradley said, thank you, Lizzie. She's actually fighting to get a writ in an unlawful detainer case to get unwanted individuals out of an elderly person's home. So it's definitely happening. And then someone requested the handout that Jeff, you were just referring to from the U.S. Attorney's Office. So if you send that to me, I'll get that out to everyone.
Okay.
And we are going to go ahead and take a 5-minute break before Marty's presentation. And so if everyone can be back here at 10:21, we will see you then.
Hello.
Hi, everyone. Welcome back. We are so fortunate to have Martin Lawyer give us 2 hours of his expertise in fair housing. And he has told me that he is perfectly comfortable being interrupted with questions. So feel free to type them in and I will get those questions over to him. Welcome, Marty.
Welcome to litigation world. Hello, everybody. Let me tell you what I'm going to do. I'm going to talk about when litigation is appropriate and when it's best. Then I'm going to go through my protocol for fair housing protected classes other than handicapped persons or persons with handicap. And then there's going to be a break, and then I will spend the remaining time talking about the protocol, which is slightly different for persons with handicaps. So, like Christy said, if I were in person, I'd be looking out at you in the audience and saying, please interrupt me with questions, because it shows that you're paying attention to the presentation and that you're interested in the subject matter. So if anybody wants me to stop and talk about something as I move on, that's especially what I'm seeking. So heading into that, why should you litigate, or when's the best time to litigate? And the previous speakers talked a lot about that. They showed situations where really the only really good solution is to litigate. And if you paid attention to last week's presentation, we're having a train of thought lost here. The presenter, Catherine Hansen, made a good presentation on how to effectively utilize the administrative proceedings when you file 903s. So, and there are good times to do that, and of course you need to do that. But when litigation is important is when injunctive relief is needed and is best, because you can't have a process that takes 10 months to 2 years before you get a result. And the threatened evictions that both Jeff and Lizzie talked about are perfect on that. And the key is winning the race to the courthouse, because whether it's state court or federal court, no one court is going to suspend an eviction proceeding. What you can do is get an injunction to enjoin your landlord or your, if it's a foreclosure, your lender, enjoin that person or entity from proceeding in state court for eviction or foreclosure. So that's why you should do it. And that gets me into, as I told the people on the committee here, what I almost always say in any presentation, going back to like 25 years ago, whether it's to lay people or to attorneys, is I usually say, if you remember one thing, well, today I have 2 things. And they are, first, get yourself admitted to federal court. You may want to go to state court, but if you're not admitted to federal court, that's going to take a while. At least a couple of days to find a friendly judge to swear you in outside of the normal circuit, and you have to jump through the hoops. And if you're in the Southern District of Florida, you have to take a bar exam, I think, to be admitted. So, and then in the Middle District, you just kind of sign up and say that you haven't done anything really terrible in the last 10 years or something. But in the Northern District, they make you take a test, something like the Florida driver's license test, where, a multiple choice is, when you see the stop sign, what should you do, A, B, C, or D? So it's not easy in those 2 districts. So you need to have that right away. And the other point that I would say, if you remember anything else, is read the statute and the exact words of each statutory section. That's why for the materials, I put in the full act. Every statute is listed separately, from 42 U.S.C. 3601 through 42 U.S.C., I think it's 3631. There aren't that many statutes because some of the section numbers don't have statutes. But you really need to look at those. And the ones that you need to pay particular attention to would be the definitions. And I could say this about any act, whether it's the Mobile Home Park Act, the Florida Landlord Tenant Act. What's the first thing you should do? Go to the definition section. What's a mobile home? It's 8 feet by 35 feet. So it's not what we think of as a mobile home, but it's how the statute, how the legislature or the Congress has defined it. So 3602 has all the definitions. And then 3604 has the main discriminatory practices. So certainly all the ones that we're going to talk about today. In real estate transactions, 3605 is important also. And then right down to 3613, which is how you get in court, either state or federal. So those are the statutes that you should have in front of you when you do the next thing, which is to draft your complaint and draft a motion and memorandum for injunctive relief, and of course have a form pleading for your state or federal indigency affidavit. And those, on your screen, my recommendation would be to put it in a separate file folder. And this is I'll expose one of my prejudice, but I think in order to be an effective attorney, you need to be obsessive compulsive. So what I say is prepare a separate file folder for federal fair housing suit fair housing suit for damages and injunctive relief in federal court, and then one in state court. So you're ready to go. And the reason is, especially in these threatened eviction cases, and this has come up quite a bit in my practice, in termination of Section 8 vouchers, of housing choice vouchers, your client's landlord is going to be not receiving the subsidy if you don't go into federal court right away, or state court if that's your preference, to enjoin the housing authority from terminating the subsidy. You need to do that. So that's when, and you need to do it fast. So you need to have all these pleadings ready with, insertable facts to satisfy your client's situation, which I'll get to in my next steps. But you need to be right ready, as they would say here down south. So now let's just go through them separately. And like I said, if somebody wants to ask a question, if I keeled over right now, you could look at my outline and my protocols, and you would have what you need to do it. I'm just going to try to give some life to these words on the page, which reminds me.
Marty, we do have a question already, if you're ready.
Did you include reference to HUD opinions in federal court pleadings? No, I do not do that. I see the question now. I'm old, but I could see, I could be Lizzie's client. Could have been Lizzie's client 18 years ago. But if I lived over there. No, I don't put cases in my, you say pleadings. In a complaint, I don't put case law. I put statutes, and we'll get to that's a really good question. So you have to put case law in a memorandum of law for a preliminary injunction or a temporary restraining order. And I'll speak for I don't know the rules for the Northern District and the Southern District. For the Middle District, your best bet is a motion for preliminary injunction, because judges don't like the advanced pleadings without more time to consider it that you would do for a temporary restraining order. And I can tell you personally, that's a bad idea, because I had adverse consequences from having done so. So there you have to have, and I'm not sure if it's in my materials or not, but if in my materials is a motion and memorandum for preliminary injunction, you would see the 11th Circuit standards as what you need to do to establish an order granting preliminary injunction. So there you cite the case, but it's only incidental to the facts of your case. The facts of your case must be pled in the complaint. And that's why, as we proceed down my list, you need to find out, first of all, what the client wants, or maybe even what the client should want. But you have to get, just like the previous speakers, especially Lizzie, you have to really get down to, what is the client trying to achieve here? And of course, in the old family law setting, we used to say, castration is not a legitimate end to this litigation, or hang him high or something like that. So if it's related, and I need to emphasize the importance today of race discrimination and national origin discrimination, because you will see frequently the effect on Black people and on Hispanic people within homeowners associations. So there you get it come up where there's a lien, and you better actually know a little bit about the condominium law and the HOA laws of, I think they're chapter 720, 721, and 722. So you know what the procedure is, because you have to act fast in those. I have an existing case right now where I'm defensive, but you have to file an objection to the lien if the HOA files a lien. And the situations you might expect, and mostly the clients and their good neighbors can recognize what this is. So if your client says, they cited me for putting this shrubbery up, or my driveway is messy, or something like that, chances are it's pretextual. That either they're taking this action against a Black person or a Hispanic person and not against white people. But you need to establish that, and that would be one of your allegations. You don't need to say what your evidence is, but you need to allege it. So, and that gets back to my maxim about reading the words of the statute. Because if you look at 3604, all the parts other than the handicap accommodation, which is really just a small legislative part of 3604F, you have to get down into 2 and 3 and 3B for the accommodation. That it's the because of, which I see is on my screen now, because some nice person did a PowerPoint based on my outline. So that's it. In other words, I can't remember who it was. It might have been Andrea last week, said, the apartment manager, may not like you because you're Black, but the manager might be a real witch as to all the tenants. So you have to, in other words, if they discriminate, if they're equally nasty to all the tenants, it's not discrimination. It would violate in that landlord-tenant setting, it would violate the Chapter 83, Part 2, and give rise to causes of action under that statutory scheme. But it wouldn't be unlawful discrimination under the U.S. Fair Housing Act. So you really need to find that out. And then, I mean, this is really kind of topical, like Jeff said. Like I have a case that we're just opening. That is actually, we're going to do it as an administrative complaint, because my client is a tenant of her sister in a subdivision where there's homeowners actions. And this is the encouraging thing about this, and what gets me up in the morning to do this kind of case, is a lot of times you will get Hispanic or Black clients who a stand-up non-Black or non-Hispanic person will say, you're right, my yard is worse than yours and they never cited me, or that sort of thing. And occasionally, if you're lucky, like in my current case, you get a quid pro quo, or not a quid pro quo, a direct violation of where a board member who's a next door neighbor to a client says, you Chinese lady, you want to, you think you can do something, but you can't, So a direct reference to somebody's race, religion, national origin, color is very important. It's probably more important where you have a lot of people from the Indian subcontinent, but it's important in the U.S. also. So you need to establish facts, or at least get enough to file them. That reminds me of another contrast between the standard that you need to file a complaint in federal court or state court, and one that in an administrative complaint. Basically, if the client gives you information that, if true, would result in a reasonable cause finding, you file that 903 for two reasons. One is you want to get the process going, and the other reason is probably your Fair Housing Initiatives Program grant, Andrea, wants you to file a whole bunch of 903s. But so that would be a reason for an administrative complaint. But when you want injunctive relief, if you want to stop it right now, you need to be going to court. So that's where, in my point 4 in my outline, which might be the next slide, I'm not sure, is that you need to conduct your own investigation. Oh, I like the pencil graphic there. All right. So, and that is, as one of my law professors said way back in the dark ages when I was back in law school, graduating in 1970, is sometimes you need to get off your ass and go out and look at the damn place, you know? So, you know, if it's, you need to see for yourself sometimes, and you certainly frequently need to interview potential witnesses if you're going to file a suit in federal court. And a person has to, especially when you're doing as you prepare the affidavit in favor and support of the motion for preliminary injunction, if you can get affidavits from witnesses, then that's really good. But the person has to be willing to testify in court, because the trial judge, and this would maybe be more important in state court, because in federal court, the judges each judge does things differently. Some like to have hearings right away, and others like to decide issues on the pleadings without having a hearing. For those of you old timers who remember our now departed Basco case, because it was overruled by the 11th Circuit, you know, you had to do the investigation and get it just to the right point where there would be no possibility of any. Well, we never had in federal court at the trial level, we never had any oral hearings. It just, everything was decided on the motion for summary judgment. Let's, like in 5, that's the standard. This isn't, you know, it's not a criminal court. You don't have to show beyond it to the exclusion of a reasonable doubt, but it has to be more than, like, the way I look at administrative law is, and my experience on this that I'd like you to know is that my summer between my last 2 years in law school, I worked as an intern at EEOC, Equal Employment Opportunity Commission in the Atlanta region, and there they took the position in an administrative complaint that it was something shorter than the over the 50-yard line that we'd like to use in the South for the burden of proof. So in other words, it would be the standard for a motion to dismiss. Unfortunately, HUD and most of the local equivalents, the Florida Human Relations Commission and the city commissions and so on, kind of almost require clear and convincing proof in order to issue a reasonable cause finding. Well, you don't need that for federal court, but you do need enough evidence to meet the probability standpoint. Or, like again, I went to law school in the South, so they explained it to me this way. You get the ball in your end zone, and you got to move it out over the 50-yard line. That gets you to the jury. So that's what you're looking for at this point. And if you have taken the time to draft your complaint beforehand, then you already know you have the structure in your complaint that makes you do this. So, and let me just digress for a second. In every complaint that I file that's based on a statute, I almost always quote the statute. So here, even though the federal judges are likely to understand the Fair Housing Act, it helps if in your complaint you certainly need to put jurisdiction in there, and the statutes that give you jurisdiction. That's 42 U.S.C. 3613. So, and I just set it out in completely. I put it right in there. And then if it's, let's say race discrimination, you want to quote 3604, and A or B, depending upon whether it's sale or rental, or if for B, it would be terms and conditions of the sale or rental. So you need to put that in there, because you don't want to have a judge, the judge's law clerk is, this attorney doesn't even know what he's talking about. It's like, show me the law. Well, you have a statute. So there you are. If there's a regulation in your favor, you should recite that. And there will be more. Stay tuned, because there'll be more on that in my second part of my presentation, because not all HUD regulations are good. So again, stay tuned for that. So I'm moving down to my point 7, which it looks like you're following my steps here. So that would be, this is when you make your determination as to whether you're in state or federal court. I can only speak for here in the Tampa division of the Middle District. I would trust every federal district judge who sits in Tampa to know this law better than almost all of the county and circuit court judges in our area. And just because of the structure of federal complaints and how they proceed, you're more likely to get better relief. Now, my friend out in Texas, Fred Fuchs, they've got, he's in Austin, they have one federal judge. He hates civil rights, so they're always in state court. So if that's your situation in Fort Myers or Orlando or Miami or Fort Lauderdale or wherever the federal courts are sitting, or Tallahassee or Jacksonville, well, Jacksonville's in our district, you might want to go into state court. And, maybe in a small county where there's only one circuit judge, so you know who your judge is. And, I was envious of you folks over there in Daytona when Shirley Green, who used to be on our umbrella group, became a county judge, because then it was great being in county court and we got some really good decisions. She's retired, unfortunately, but so if you absolutely know who your state court judge is and that the state court judge is likely to be favorable, then that's where you might want to go. So that's when you make this determination. I tend to go toward federal court because it's a federal statute. You have a right of action. Of course, federal court is a court of limited jurisdiction, but that's what's so great about 42 U.S.C. 3613. It gives you that jurisdiction. You don't have to try to piggyback on 1983 or something like that with a more obtuse way of getting into federal court. So,
Marty, if you don't mind interrupting, we did have a question come in,
sure.
And it ties right in with this. Are there any requirements to exhaust administrative remedies before filing in court?
Aha, that is such a good question, because it was always clear under the U.S. Fair Housing Act that there is no requirement to exhaust administrative remedies. Then I'm going to give you the structure of the Fair Housing Act, but I would like to contrast this with the Equal Housing Opportunity Act, EOC, because there you do have to exhaust administrative remedies. And then under the Federal Employment Discrimination Act, a finding by the administrative agency can be used against your client or in favor, if it's favorable, in any lawsuit. So it's just the opposite under the U.S. Fair Housing Act. And in order for any state agency, whether it's, excuse me, the Florida Commission on Human Relations or, your local city human rights or human relations board or whatever, it has to be substantially equivalent to the federal law. And the Florida Commission on Human Relations almost got decertified because the Florida statutes said that you did have to exhaust your administrative remedies. And I believe there was, for a time, one of the district courts of appeals said that. So the Florida legislature, possibly, well, I won't speculate as to why they did this, but it did protect a lot of jobs in Tallahassee. Let me just put it that way. In this current legislative session, they just passed an act that does not require exhaustion of administrative remedies. So that, to me, that is another point in favor of litigation. And a couple of the litigations that I pursued, one of them, we actually had an adverse decision by the city of Tampa's, Tampa Office of Human Relations, TOR. So, which, so I said, took the jaundiced view of my client's evidence. But when we got ready to file suit in federal court and I prepared a complaint, oops, they settled it for $10,000. So it maybe I over answered your question, but but no, you do not have. That's the beauty of the federal act. You do not have to exhaust state remedies. And if by chance you get an adverse decision, if you did pursue your administrative remedy and there was a finding of no reasonable cause, that can't be used as a defense in a lawsuit that you would bring. So they could use the evidence that the state or city or county agency used they can cite that evidence in their answer or when it goes to trial, but they can't use the fact of an administrative finding against a plaintiff in a federal fair housing suit. So, okay. So then, what I'm going to say next, this is my point 8, is, and this is just good practice. And I think for those of us under LSC, it's required that if it's LSC, you better get your LSC statement of facts in order so that the client knows what you're doing, which is a short, simple statement in the language of the client that explains what you're doing and the result you hope to achieve. So, and part of this is to send a demand letter. Turning again to contrast and bearing in mind my current case that I just took last week on the HOA is in the litigation, you really should send it. You really need to send a demand letter, and I'll tell you why in a minute. But in the administrative complaint, it doesn't really solve anything. So I have no qualms about filing a 903 in this case against the board member, and I could CC the law firm when we file it, which will probably be toward the end of this month as we develop the facts. But with what you want, and this is what I said at the start of my outline, which I didn't directly say until now, what your goal is, as you're walking your file over to federal court to file it, at least in Tampa, you're supposed to file the initial complaint in person. If you can electronically file it. Well, as you're hitting send, you want to say, this is damn good. I have alleged facts that show we gave the defendant every opportunity to avoid this litigation. Judge, we're in court because they weren't reasonable, and they had every opportunity to give us what we want, but they stonewalled us or whatever. So that's a purpose of the demand letter, and you might get a response back. Before Basco was overruled, we would send letters to the head of that Section 8 office at the Housing Authority, City of Tampa, and say, if you don't respond by such and such, we're going to file suit. We usually got a response said, oh, don't file suit just yet. We're going to reverse the hearing officer's decision. So you might get what you want by sending the demand letter. You also might get, and this is just fun, you might get a response that essentially admits the conduct. And then, of course, all of that can be in your complaint. So in response to the letter that plaintiffs' undersigned counsel sent on May the 1st, 2020, defense counsel sent back this response of, from the board member that they had a right to do this against non-Americans or something like that. It's like, that would be pretty blatant. But sometimes, especially lay people on the other side will, if you send a demand letter and you don't know the person has an attorney, you might get a landlord or somebody that sends back a letter that, uses profanity or, is very unflattering to that person. And then that becomes one of your exhibits in the complaint. So that's, you send a demand letter for two reasons. One is you might actually settle the case. And the other is you're providing more evidence of the unreasonableness of your opposition. So we're down at the end of the good part here. So we're almost at the end, because my outline on this is one page. It's a little longer on the handicap accommodations and such. So, my last point on this is you use the marshal service to serve the complaint unless it's a complaint against a state agency like a county. And in our Basco case, in the Section 8 setting, the county under Florida's service of process statutes is entitled to be served by a deputy sheriff, by the sheriff's office. But otherwise, the marshal can serve anybody. And if you're entitled to the indigency, the IFP, the informal pauperous status, then you get free. Which, by the way, that should be decided right away. In other words, you should be able, and most of our judges in Tampa, federal judges in Tampa, are pretty good about this, is they will give you a ruling, an order granting your right to proceed without prepayment of costs within a week, within 5 working days of when you file a lawsuit. And then you're ready with your summonses and everything, and take them to your deputy clerk, and they get it to the marshal's office. And if you want to, you can actually, I happen to know where it is on I think it's the 3rd floor of the federal courthouse here in Tampa. Is I like to have the clerk issue the summons and then walk all the process up to the marshal's office, where, again, know your local office, because there you ring a bell or call a number and somebody in the back answers it, comes up and takes your process. There's nobody live out front. So that's one of the things that I want to mention, since it looks like I have a minute or two, excuse me for cough, is how, and this would answer the question of a person earlier, is what do you cite in your memorandum? Let's say it's the effect of the pretextual use of some kind of criminal investigation to take adverse action against your client. You want to use the language that's in, and this should be in the materials, of the HUD the U.S. Department of HUD's Fair Housing Division's legal counsel opinion as to the nexus between criminal indictments and charges, and that it's disproportionate as to Black and Hispanic persons. And certainly anything on that, if you allege sex discrimination, if you have a domestic violence situation and there's something that on the surface might apply to everybody, and there's just no, factually, it's fairly well accepted evidence that domestic violence injunctions are, I mean, this is like 80% of them are women are the victims. So if a landlord has, in effect, says anybody who, you know, an abuser comes over, breaks down the door, and then says, well, your door's broken and it was your invited guest, well, that's sex discrimination. So, but getting back to the race and national origin related to the criminal things, and here I want to give a special credit to the lady who was head under the Obama administration, was head of the Fair Housing Division of the U.S. Department of HUD, and that's Sarah Pratt, who's now with the law firm of Relm and Dane. But she wrote that memo so well, and the people under her so well, that you don't cite the memo, you cite what's in the memo with the Supreme Court authorities that are in that memo. So you don't ever want to say the defendant has to do this because of this HUD memo. You say because of the legal principles established in the, you know, the cases that are cited within that memo, and most of them are in the footnotes. So you really need to read that. Okay. What can you do if you send a demand letter on the other side? It gives you what you want, but client still has out-of-pocket expenses. Oh, that's a good question. So then you should have put in your demand letter that you want compensation, because your demand letter should say whatever it is you want. So if you want compensation for your client, of course it has to be legally justified. You should put that in the demand letter, because let's say, you know, in the one case that I had where it was a handicap accommodation case, where eventually, because we filed lawsuit, they did transfer my client to an acceptable dwelling, but she still had expenses, and it took them like 6 months to do that. So the lawsuit stayed alive. But in the but if you can legally justify a claim for damages, that should go in your demand letter.
All right, great. We had one more question come in before we take a quick break for the next part of the presentation. If the adverse party does file the determination of no cause in the pending case in court, does the plaintiff move to strike that filing?
That's what I do. I mean, well, I don't think it would arise in that situation. And any, you know, you have to know who the attorneys are at the other side. But I don't think any attorney worth his salt would do that. But if they, let's say their answer of an affirmative defenses, or if it was then attached to a motion to dismiss or something like that, which you could always, I mean, that's the gold standard, is your complaint has to be able to withstand a motion to dismiss for failure to state a cause of action. And I probably should take a couple of minutes to say how you, I mean, probably a lot of you know how to do this. But if you have a lot of facts and different causes of action, you need to put your facts all up front, and then very selectively allege by reference the paragraph numbers that support each cause of action. You can't say incorporate by reference all the preceding paragraphs for 5 causes of action. You know, that's what you call a shotgun pleading, and that is going to run into trouble. But because not every fact alleged will support each cause of action. So, all right. Did I answer the question enough, or tell me more if you want?
I think so. So if anyone has any questions at this point, we're going to take a quick break in a few minutes, and then Marty will move on to the handicap accommodation section of his presentation. So any last questions before we take a break? Okay, I have one more question. Do you have advice on determining damages, especially emotional distress, including for writing the demand letter?
Could you repeat the question?
Sure.
I didn't hear the first part of it.
Oh, okay. Do you have advice on determining damages, especially emotional distress, including for writing the demand letter?
That would be interesting. You know, well, first of all, when you get to damages, usually the federal courts defer to what the state standard is. And Florida is terrible. So if you have a fair housing case on that, if you want to sue for emotional damages, you should be in New York or something, because Florida has the contact rule in suits for intentional infliction of emotional distress. So there has to be physical contact for you to get emotional distress. You can get, quote, special damages. In other words, if, let's say, you suffered physically in some way, or the emotional damage caused you to miss work because of the delay in responding to your request. Let's cover that a little bit more in the second part of this. But Florida is just, I mean, there is a case out of the 3rd DCA in Miami that was upheld by the Florida Supreme Court that says, I can yell at you, I can do anything I want to you and insult you and try to hurt your feelings, but if I don't touch you, you lose. So, I mean, that's the so-called contact rule, and this is a tort concept that would take you maybe back to law school on it. Defamation and intentional infliction of mental distress. So you have to express it in some other way. So yeah, I'm having a hard time. I'll tell you what, while we take a break, with the person who asked the question, give me a specific example that he or she has in mind, and then ask me about it then. And what, just as a clue, what I'm going to say when we come back from the break is probably going to be fairly provocative. So I expect some questions. Okay?
Well, with that teaser, we will definitely take a 5-minute break, and that'll give everyone time to digest all the information and come up with more questions. So I'll see everyone back at 11:10. Welcome back, everyone. Marty, we had some more information come in from the audience member who asked about emotional distress.
Okay, let's go with that.
So here's the pattern. Landlord, knowing tenant has mental health issues, would not give her the keys to the unit until she signed an agreement and got renter's insurance the morning of the move-in, knowing her movers were on the way. She did get the keys, so she was not unhoused, so no preliminary injunction, but she was very disturbed.
That's a tough case in Florida. And by the way, while we were on break, I was thinking, I know from last week's attendees, some were from out of state. So when I said DCA, that's District Court of Appeal. It's our Court of Administrative Appeals, Intermediate Appeals in the state of Florida. You have trial courts, county courts, and circuit courts, and then you have the courts of appeal, and then you have the Florida Supreme Court. So a person who hates acronyms, and I used one. So there. That's a tough situation. There are other ways. I mean, that's one. I don't know about putting that in a demand letter. I would just say we're going to file suit, and we might make a claim for incidental damages. And my client and I have agreed that in order to avoid unnecessary litigation, my client will accept the sum of $1 million. No, accept the sum of, you come to something that you think the other side's going to pay, or maybe twice as much as you think the other side's going to pay. In other words, if you want 1,000, say, ask for 2,000. I mean, that's just basic litigation trial law. So principles. Okay. And we can come up on that again, because again, we're talking handicap here. But before, I want to talk about knowing the actual words of a statute, something that I should have said in the first part of this, and that's on familial status. Because the words of, and this is subsection K of 3602, I used to think of it just informally as marital status. It's not marital status. There have to be children involved. So you need to look at the exact words on that. So it has to be discrimination against families with children, although that is not the term in 3604 either. It's familial status, but practically speaking, that's what it means. Okay, now, something else that I could have included in the first part, but will now include is, and that is, when you get to the end of this, and the protocol for accommodation advocacy and also for the more direct discrimination against persons with handicap are covered in 3604F. So whether it's handicapped or non-handicapped, when you're headed to court, in any case, I like to think that every lawyer should have a musical theme, sometimes with words or lyrics. My personal theme on the way to the courthouse is the Empire Strikes Back theme, the Imperial March. So it psychs me up for going to court. so you might want, based on a name, or maybe there's a high school basketball cheer, like we're going to whip upside your head cheer, that you feel like shouting as you're going over there. Because to me, one of the best ways to support the U.S. Constitution is to file suit under a U.S. Act of Congress. And when you can do that, you should feel good about yourself. So, all right, that's my pep talk. Now, so again, the exact words of the statute. And I'll get to the definition of handicap in a second, but don't lose track of what you need for handicap accommodation, because you can, when I started doing this 20 some years ago, you could divine what's required, the elements of the cause of action. And this would be in any litigation case. I mean, if you file a tort case for an auto accident, that was established, 100 years ago. So you know what the elements are, and the Florida rules of court helpfully provide you for those elements, or a suit for garnishment or something. There's statutory. So for handicap accommodation, And you kind of have to read the statute very closely and go backwards and forwards. But the 11th Circuit Court of Appeals, and for all of us here who are from Florida, Alabama, or Georgia, this is what it is. And I would almost guarantee that every other federal circuit has defined the elements of a cause of action in a similar fashion. So, you know, it's in the handout, but it's a 4-step process. You know, Jeff talked a little bit about that he's disabled, and I'll get to that when I get onto the definition of handicap, which the 11th Circuit calls disability, but the statute still says it's handicap. So we'll talk about that in a minute. But, and then that you requested a reasonable accommodation. This statute, this part of the statute is not self-executing. You can't say, well, my landlord or my lender or the seller should have known that I had a handicap and I needed an accommodation. You have to ask for it. And this is where the attorney comes in, because you can frame it in your demand letter in legal terms. So, and I'll get into the proof of that in a minute, but the third prong is that it's necessary. So, and it's not desirable. So when I send, you know, Andrea accurately quoted me at the last presentation where I was listening and not talking, that the statute doesn't say you need medical proof, but if you don't have it, you're going to be in trouble. So because you have to show in my letters, I have a form letter that I, of course, modify every time I send it to a doctor or a healthcare professional, and it could be a psychological social worker. I list the order of importance later on in my outline. But you say, okay, say that this person has a handicap, and I send them the definition of handicap right from the statute, 3602H, which is conveniently subsection 8, defining the word that begins with an H. So, and say, can you say that whatever my client's condition is satisfies this? And secondly, whether they need, in the present circumstances, what prevents them from receiving the benefits as a normal tenant, or what is needed to accommodate my client. So a little more on mold on that. But so then that's how you establish it. That's part 3 of the element of the cause of complaint. And from the questioner in the first part of my presentation, this is stuff that needs to go. It needs to go in the complaint. Now, I would not in a complaint put, you know, these elements and then cite Shaw versus Habitat for Humanity I put in too many words in my citation in the case there, of Citrus County on that. I would just allege those 4 elements. In the motion and memorandum of law for a preliminary injunction, then I would cite the Shaw case. And like I might have said elsewhere, the trial court judge at the U.S. Middle District of Florida, Tampa Division, is the now senior status Jim Moody, who is, I would say, a personal friend, but on the more conservative side, and he got reversed in this case. So it was kind of, which of course, tactfully, I have some tact. I won't bring it up to him the next time I see him, but it's a good case. And the thing about, if you don't know this already, the federal judges in each division, they all talk to each other. This isn't like the U.S. Supreme Court where the justices never talk to each other except in conference. They don't walk down the hall. The district judges all talk to each other. So if one of your district judges in Orlando gets reversed and you file a case and it's before a different district judge, you better believe that your judge knows that his or her compatriot got reversed in another case. So, okay. So then you get to the necessary. The reasonable part is very, very important too, because that's where you get with the landlord. it would be like an affirmative defense, a response, say, yeah, they need, well, it wouldn't be a modification because modifications are in a whole different category. But an accommodation, if it would cost the landlord way too much money, that would make the accommodation unreasonable. But you get past the motion to dismiss by just alleging that this request is reasonable. Got to stop saying, it's bad speaking. All right. In my first case, in which we had an accommodation request to transfer my client from a studio apartment to a one-bedroom apartment, we said it's reasonable, and it would be up to the other side to say that it's not reasonable. So, but you get past the motion to dismiss by showing some fact as to why it's reasonable. If it isn't going to cost the defendant any money, then to me that would be reasonable. And finally, actually number 4 is really easy, because if you make the request and they refuse it, then you satisfied that requirement. Okay, what kind of damages? Okay, somebody asked, what kind of damages can you receive in federal court? I'm glad you asked that question. 3613 says you can get, let me look at it. If I can find it. Get basically any kind of damages, including pain and suffering and so on. So, and punitive damages. So I have to look at so you look at that, again, look at that statute very closely. If I got I think I have that on one of my screens here at home. Well, again, what I would say is look at 3613 and okay. Okay, rather than take up time now, I was going to try to get, I apparently don't have 3613 up on any of my screens. Well, maybe I can get it here. Let's go. For an old guy, I'm pretty good here. All right, enforcement by private persons, 3613. It's pretty open-ended. So let's see. Oh, yeah, so it's under subsection C, relief which may be granted. Actual and punitive damages subject to subdivision D, which is effect on sales and encumbrances, which is not relevant to us. And all kinds of injunctive relief. And you get an attorney's fee. So, and there the attorney's fee standard would be probably better than in federal court than state court. Oops, where was I? Okay. Well, let me go on. We haven't even, okay, let me get when I called up my word processing documents, it obliterated there. It obliterated the webinar screen. So are there any more, before I move on, are there any more questions after the one on what type of damages?
No, we don't have any more questions yet. We just had a good well wish from someone that said, "May the 4th be with you, Marty."
All right. See, right, because I was a Star Wars reference. All right. Da, 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 da. All right. Well, okay, let's go in, and this is the real provocative part, because within the, quote, disabled community, they don't like the term handicap. But I need to give you, that's, in terms of legislative analysis and construction of statutory construction, you have to go back to when the Fair Housing Act was amended in two ways in year 1988. And by the way, it was President Reagan who signed these amendments into law, which, think about that, in a kind of policy stand nowadays. So there were two major changes. One was the familial status, and the second was handicap discrimination. Well, what did Congress have in front of it for a model for handicap? They had what was then called the Education of All Handicapped Children's Act. And so handicap there, I mean, like I said in my outline, you really need to think about it as an open-ended thing. It's not categorical. If you get Social Security disability, it doesn't entitle you to it. If you lose it, you're not entitled. If you're denied it, you're not disentitled to it. If it basically is a person by person determination as to some kind of impediment to what the client wants to be treated like a normal tenant or a normal home buyer or a defendant in a foreclosure suit, to be treated normally. So now here's what happened. So somewhere either in the late 1990s or the early 2000s, Congress changed the Education Act to use the term disability. So then the name was changed to the Individuals with Disability in Education Act idea. Congress had many chances to change the definition of handicap to disability and chose to not do so, or didn't choose to do so. In Congress, you have the principle of inertia. It takes a lot more to enact a law than it does to repeal it. So, but it really, why I would tell you, and by the way, you can use the term disability in the 11th Circuit because those judges decided to rewrite the statute and call it disability, even though the statute itself says handicap. So you're not going to get in trouble if you allege disability and refer to 3604F or 3602. Handicap, you could say it means the same as disability, whatever. But what it really does is limit your thinking. So it doesn't matter from purposes of fair housing discrimination, for handicap discrimination, whether some agency determined that HIV or full-blown AIDS is a handicap or a disability. What you have to show is the effects of your medical condition or psychological condition require you to need an accommodation. So, I mean, and you get a lot of misinformation on this. I remember one time at a Section 8 termination hearing where this is one of the counselor's supervisors at the hearing said, well, okay, so we gave her Social Security, we gave her an accommodation because she has Social Security disability, but under the law, you only get one accommodation. Well, that's what you would call doubly wrong, because you can get an unlimited number of accommodations and they change. So you need to, right. So I said direct sunlight, and that it was like, I mean, my thinking was not always this expansive, but I remember going to a probate and guardianship seminar back in the 90s, and they had just passed the new Florida Guardianship Act, and the speaker, a man named Bill Belcher, who's deceased now, they were talking about special needs guardianships, whereas before you had to either show you were mentally or physically incapacitated almost totally. Excuse me, I'm coughing. So he likened it to this. His mother liked to play bridge every afternoon. But when she had to play at somebody's house that was east of where she lived, she needed somebody to drive her home because she couldn't look at the sun as she was driving east to west in the afternoon. So that's the way you need to look at handicap and how we get such wonderful rulings in the case law. Again, this would not be in the complaint, but you'd be ready for it in your in your motion for a preliminary injunction. And I mean, it was the Sixth Circuit that found that a person was entitled to have a miniature horse as an emotional support animal, and invalidated an entire city ordinance that prohibited it. So you just need to look at it in a very expansive way. And HUD, I remember Sarah Pratt talking about this when I first got assigned to the fair housing team. This would be like 6-7 years ago. Was HUD took a case all the way to the 10th Circuit on a canary as an emotional support animal for this kid. But because of the peculiar facts, in fact, this kid had gone to live with his grandmother from Oklahoma or somewhere to Colorado because his parents had been murdered in front of him. And his only way to keep calm was to have this canary. So HUD took that, and HUD can join your case, by the way, took that all the way to the 10th Circuit out there, got dismissed at the trial court and won it, because that was you wouldn't get Social Security disability course, but you sure as hell can get you certainly can obtain relief for an emotional support animal under 3604 F2 and 3B by showing your obstacle is supported by evidence and it needs an accommodation. So I hope I've opened your minds on that. And because you can't, it's interesting if you get it's helpful if you get a determination by some agency that COVID-19, if you're tested positive for it, it means that you have a certain disability. But honestly, even if the Secretary of HUD or the President of the United States said, I declare that everyone who has COVID-19 with active symptoms is entitled to a fair housing accommodation, that wouldn't be the law, because that's not the way Congress wrote it. And by the same token, if they said, no, COVID-19 doesn't prove anything, that would not be determinative either. Okay. Well, okay. It's only 11:35. So the rest of this, there is one side part, because mold cases are different. So, oh, right. So whoever did on point 4, yeah, whoever did this, I liked this about the examples, because it's a little easier to read than in my outline. But if you get to a licensed mental health counselor, I'd use that. But in terms of downward, in other words, your best evidence is an opinion as to your client by a physician specialist. There you go. Put it into 9 terms. I like numbers. So it would be a psychiatrist. Psychologist is pretty close, especially if it's a clinical psychologist. Then you get to osteopathic doctor, a general practice specialist, a general physician who's a general practitioner, an internal medicine specialist, it always helps if the physician is your client's treating physician. And you get, I mean, this goes to the weight of the evidence. If you get a letter from Dr. Jones that says, Ms. So-and-so has been my patient since the year 2011, and I have observed all of this over a course of 11 years or 10 years, 9 years, I guess I got to do my math. And she has these handicaps, and because of this, she needs these solutions to the handicap. And it is neat. It's not, it would be desirable. I think either Andrea or Lizzie pointed that out last week, that an opinion on a prescription pad is not a good idea, especially if it says it would be really nice if Ms. So-and-so or Mr. So-and-so had had an animal to help him ease the tension in his mental life. Oh, and on animals, again, if you want to win, what I would say is you want to name the animal and describe it. A mixed breed named, Fred or Fido or some such, and who is, and then the health professional says, patient so-and-so needs this animal as an emotional support animal. My favorite example of this, and this was a housing authority case for an accommodation of pets in public housing when we still had public housing in Hillsborough, locally here. All a rad thing, which is a whole nother issue. But I had a client with 4 pug dogs, and she was treated county medical services, government provided services. She had a psychiatrist who said that my client needed all 4 of those dogs in order for her emotional stability. So, and when, I think, again, Andrea or Lizzie, I forget who said this last week, is you do need to have to file a complaint, you don't need to show that the dog doesn't bite people. But if you have an emotional support camel, you better be ready to prove that that it's reasonable and it won't disrupt the landlord's other operations of the leased dwelling. So, or a vicious dog that has bitten numerous people. So let me move on, if I may, to the mold issue, because in mold cases, then the attorney, this is an advocacy thing, bearing in mind that I had done any litigation, I think maybe one time on familial status in a defensive measure before I got assigned to the fair housing team in 2013, is this protocol I developed on my own, just using the Section 8 termination protocol as a guide. In a mold case, you have 2 letters to the doctor. The first letter is, does my client have a medical condition that would be adversely affected by poor air quality or bacteria or other other imperfections in the surface area of the dwelling? So then you get this is the good response. You get the response, yes, your client has a respiratory problem. It's affected by both air mold and surface mold. So then, I mean, I guess if you're Matt Dietz, by the way, the go-to person on handicap advocacy in Florida is Matthew Dietz, Matt Dietz, who is out of Miami and is happy to consult with you. And I don't think he'd mind me telling you that. It's what is his acronym? He has a solely owned corporation that's advocates for handicap or something like that, which I forget what the acronym is, but it's really cool. So if you look up, either type in Matthew Dietz in a Google search, you'll get this. But he may have unlimited resources. But those of us in legal services, we can't be tapping into our litigation fund every time a client alleges something. So, internally, for us to justify the use of an expert in air quality for an inspection, we have to have a medical statement. There we go. Thank you, Christy, or whoever's flipping the slides. And actually, since I wrote this, the price is going up to like $550 or $600. And so to get this approved, we have to attach to our request for quote major expenses within Bay Area Legal Services that the client has a condition that if there is unsatisfactory air quality or surface quality that needs to be remedied or remediated in industry term, then you have to prove it. And one thing that I learned, this could have been as long ago as 25 years, is the county ordinances and city ordinances have a really high bar for any kind of determination that there's mold. I mean, it could be, you can't go by what you see. You need somebody with a scientific background to take samples and then give you an opinion. Our opinion letters that we get from, and we use Indoor Environmental Technologies in Clearwater, run 10 to 20 pages. And the scientific evidence that they report, I mean, there's no dispute. And occasionally we'll find out, nope, no mold, or the carpet is slightly moldy, so all you need is the carpet replaced. But then other times, I mean, that's why it's fact-based. There was one time when our personal examination of the dwelling was that it smelled moldy. So we got, the client had a respiratory problem. And by the way, this is a quadruplex. So there are 4 connected units. So Indoor Environmental Technologies goes out there, it takes readings. Well, guess what? They didn't find any mold, but they found fiberglass particulates all throughout the dwelling because of defective lining to the ductwork that connected all 4 apartments. And this was very satisfying because the owner of the quadruplex is the Mental Health Association of Hillsborough County, which, by the way, is the largest landlord. They kind of are under the radar, but they're the largest landlord in the county. So they're supposed to be helping handicapped people, and at least they saw the light on this. But they had to spend thousands of dollars to redo all the ductwork in all 4 apartments. So you just never know what you're going to get. And a lot of times, so then you do get mold, and then you tie that to what your client wants, and the client just wants to get out. I have a current case where it's project-based Section 8, and chances are, if there's mold in her place, she can't move to another one. They could, and if it's project-based Section 8, of course, you can't move a voucher. You don't have a voucher to move. So there we got remediation. And they did. They sent out people and took care of the mold. But in other cases, and this would be, again, experience based that you may not have thought of, but the cases will come in your door. You have somebody. Oh, and by the way, when you go back to handicap definition, everybody can understand mobility impairment because handicap, or if you use disabled, means you must be found eligible for Social Security, or you must be in a wheelchair, or something of that nature. But what you get, and I've had 2 clients, is interesting that it's come up the same way, because it wasn't physical injury, it was being diagnosed with and having cancer that caused the person not to be able to climb the stairs to go to a 2nd floor apartment. Well, if the landlord doesn't have any first ground floor apartments, then your remedy is just to terminate the lease. And sometimes you get resistance from the landlords that say, oh, we're not going to do that. And furthermore, if you move early, we're going to charge you for a termination fee. Well, so we had one of those, and fortunately, my client was able on her own to relocate to a tax credit property with using her voucher, and that had elevators. It was actually a really nice place. And the place she was moving out of wasn't bad. It was Carlton Arms here in Tampa. It's just that she needed to be on a ground floor apartment or in a building with a serviceable elevator. Okay, so getting back to the mold. So then you get the results back from your environmental testing company, and there are other places all over the state, by the way, that are doing this now. And I'll give you an aside in a minute, but you get those results in your 10 to 20 page report, and you send that to the respondent, to your opposing party, and say, this is what we want. So, and you do have to be specific. So in the case that for remediation, we want you to correct this situation. We want you to remove the mold. And if you don't do it, then we're going to seek injunctive relief to let our experts do it. So I have to say that the attorney on this is on the other side, and this was a former Bay Area Legal Services attorney, and the big law firm of Mike Davis's law firm, MGFD or something like that, law in Clearwater. They know the handicap law pretty well, so they immediately had their own inspection and remediated. So, okay. But if you get denied, then and you need injunctive relief, that's when you go to federal court. If it's sometimes you will get cases in your office from a client who suffered for like 6 months at a previous place and asked for the accommodation, which does not have to be formal, but it's easier to prove if it's in writing, and then was denied and suffered for 6 months and then finally moved somewhere else. You get a case like that, then administrative is as good as in court, because you get into a judge on that. It's just, why are you wasting my time with this case? This client only needs like $4,000 or something. Because to like circuit judges, and they just revise the rules, it's not a real case unless it's over $50,000. So it's just the way judges think. So there we are, filing the lawsuit. How much time? Oh, 10 minutes. We have more questions. Let me look at my thing. I don't see any more questions in my little chat box. But like I said, you get to that point, and then you're in court, and you got to be ready to. You need to know your local rules on the time deadlines. We have in the Middle District, we have category Roman 1, 2, and 3 for how cases proceed. So you need to know that, and you can't just say, okay, we filed it. Because if you don't get service in 60 days, you're going to get dismissed. And if you don't comply with the pretrial conference order, you're going to get dismissed. So you really need, the burden is always on the plaintiff to keep the case moving. And in federal court, it's especially important. That would be one advantage, I guess, if you're in state court, where you can just file it and scare the hell out of the other party and sit back and see what happens. But in federal court, if you're the plaintiff, you have to move the case, or you're going to get dismissed. Okay. I think that's it.
All right. Thank you so much for all that information, Marty. We did have some questions come in. There's a hidden question box you probably can't see. So let me get those over to you.
Sure.
So first is a compliment. Marty is awesome, which we all agree on. Now for the question. Okay, I hope I'm understanding this question correctly, and the person asking can type it in if I'm not. What is the best way to explain those landlords who have 3 or fewer apartments, or maybe they live in one of the apartments? Can they get away with discrimination except for race discrimination?
I would say we don't usually deal with that and my program under the FHIP grant. But if I had that case, that would be one where I'd want to go to state court, because I don't think they have the 4-unit requirement. So, but I'll have to plead ignorance on that. I would have trouble filing that in federal court. But don't be dismayed, because, this is where, that it may be that the XYZ Corporation owns this one property, or be very wary of the Burt Reynolds law, which is is the trust law in Florida, which allows people to own houses, own real estate in trust without disclosing who the owner is, except upon litigation. So if you find that your client's landlord, is in a duplex, and it's the John Smith trustee or the John Smith Trust, then you need to find out if there's any other or if it's anybody, any corporation, and you can almost always add up to 4 in those. Now, if it really is grandma and grandpa who just decided to go to a senior facility and rented out their former house, then that's not subject to the Fair Housing Act. On the other hand, that's one of the worst landlord-tenant situations you can have. I discovered, I don't mind telling you, I've lived this long. I was already practicing for 3 years when the Landlord-Tenant Act went into effect. But I can tell you, and I didn't start really doing landlord-tenant law until I came with legal services in '73. So the worst case scenario is the former owner is the landlord of the house, because they're driving past that house and they had it, maybe their grandparents owned it first. That house has been our property for 50 years, 60 years, and now these renters are destroying it. So they just lose sight of reality on that, and just, those are tough cases. But usually you beat the landlords in those situations, because if I was talking to landlords, the one thing I would tell them is, don't be undercapitalized. You have to have enough money in the bank to cover periods at which your dwelling is not rented, and you have to make everything clear in writing. So as to have a written lease, so everybody knows what's required.
Yeah.
So. Okay, great. And someone typed in the acronym you were trying to think of, Disability Independence Group, for Matt Dietz.
I don't understand the question. What about disability independence groups?
It wasn't their question. It was just the law firm of Matt Dietz. It's called Disability Independence Group.
Oh yeah, dig it. That's right. It's like, this is somebody my age would have, back in the 60s, if you were at a jazz club, can you dig it, baby? So he's way younger than I am. But his acronym is dig it. I knew that. Or maybe you would say digit. I would be careful about that.
Yeah, lots of thank yous for the information. And I do want to remind everyone, we have a few minutes left. If you have questions for other presenters, I can unmute everybody if you have questions for them. Now is the perfect time to ask all those questions you've been wanting to ask when we have all these experts on the line. There was an additional question. I'm not sure I understand it exactly. It was related to the one where it's the small-time landlord with only a few units. Are they allowed to discriminate in advertising, specifically to say no to disabled tenants?
Well, my answer would be the same. If that's really the case, yes, because depending on, you might be in a city where that's covered by an ordinance. Actually, a lot of those things, like here, the city of Tampa has ordinances. The Hillsborough County, Pinellas County has ordinances. It might be covered under those. So you can get to the problem maybe under your local ordinance. But also, I mean, I just, yeah. Oh, and by the way, on the credit thing, this gives me an opportunity to say this, and don't overlook the Fair Credit Reporting Act, because any landlord who uses a service to do credit checks is subject to the Fair Credit Reporting Act, and also would be subject to the Fair Housing for discrimination in renting, in the rental. So if you have, you know, this would require some proof, but if you have landlords who won't rent, who specifically, or their agencies say that they will report bad credit of anybody, if they will take into consideration anybody who has a lawsuit filed against them, then, I mean, that's in the same category with adverse consequences to people of color and to racial and national origin discrimination, because the fact that you've had an eviction suit filed that you have filed against you, or maybe you sued the landlord, and your client sued the landlord, and a private attorney, a private landlord who doesn't use the service can base a rental decision on that. But the minute the landlord who owns one property uses a service to do a credit check, then that service is liable under both the Fair Housing Act and the Fair Credit Reporting Act. And also, you know, that is, well, I'll just leave it right there.
Thank you. And we got several compliments in here. Thank you to all the presenters for such a good webinar and for sharing your knowledge and expertise in this area, which is a perfect segue into what I was going to say. Thank you to all of our attendees for your attention. I know 3 hours is a long time and this was a lot of information, but I really, really appreciate each and every presenter. They put a lot of hard work and time into this in the midst of their busy day jobs and also with a pandemic on top of it. So I really appreciate all of you sharing all this information with us, especially Andrea Mosley at Community Legal Services, who put the agenda together and has been working closely with me to put these 2 webinars on. So thank you so much, everyone. Any final remarks?
Thanks for having us. Thanks for hosting, Christine. Thank you, all the presenters. It was amazing to learn from all of you and have you all participate.
And we already have someone who wants these to be done again. They both have been recorded, and I'll send everyone the link to the video and the shared drive with all the materials. Jeff Hussey already sent me the letter from DOJ that he referred to earlier, so that will be in the shared materials. And that's it for now. Thank you, everyone.
Let me add one thing in closing, if I may, and this is Bob Marley reference. Stand up, get up, stand up for your rights. That's what I want to leave you with.
Absolutely.
Marty.
Thank you, everybody. Take care.
Take care, everybody.
Bye-bye.